So, a very good evening to everyone present here. I am Riddhi Jindal, COO at LawInternships, the online law school, and the moderator for today's interactive session. First, I would like to brief little about LawInternships, the online law school. LawInternships is an online law school which extensively provides educational services. We provide opportunities in the field of law to the students pursuing undergraduate or postgraduate programs for gaining professional experience as well as to improve their legal skills while being enrolled in a full-time law program. The objective is to provide a credible platform for the law students to fulfill educational requirements by imparting practical exposure and relevant skills. The uniqueness of the school is to unlash a law school whereby students get an opportunity to hone their skills outside a classroom environment and provide a wide range of services to the students for their holistic development. Today, we have amongst us Mr. Pawan Reley, sir. Sir is an advocate at Supreme Court of India. He's also co-founder of NIEV Judicial Education. He's also authored a book analyzing the constitutional validity of the 99th constitutional amendment in the light of NJAC verdict 2015, namely Judicracy versus Democracy Revisiting Fourth Judge Case. He has published more than 25 articles analyzing the constitutional validity of various laws in various prestigious platforms. We welcome you, sir.
Thank you, Riddhi.
So today, sir, we'll be discussing about the due process of law vis-a-vis procedure established by law. So I request the participants to keep their videos on and mics on mute. And if in case anyone will have any queries, questions, you can raise your hand and we shall recognize you and unmute you. Or you can even write down your queries in the chat box. In the end, floor shall also be open for any questions. So without delaying any further, let's begin the session for today. Over to you, sir.
Okay, thank you, Riddhi, for giving me this opportunity to speak in this such an important topic. Uh, Hello everyone. I'm Pawan Reley. I do not want to make this session boring and monotonous. So I want all of you to have good interaction because this is the concept which is bit heavy and it's bit complicated concept. There has been a constitutional assembly debate, and from constitutional assembly debate to AK Gopalan judgment, this concept is still many people confused. Even the jurist, there's a problem in the jurist also. They also get confused with this particular problem. So we need to understand this today. The object of today's session is not just to give you a lecture on this particular topic, but to make you understand the concept. Because many of you may be knowing the difference between procedure established by law and due process of law. But actually, there's a trick in this, and the trick is that even the due process of law is divided in two parts. Okay, one is called the substantive due process of law, and one is called the procedural due process of law. So, in way, there are three concepts which we are going to go through. Okay, Riddhi, am I audible to everyone? Am I audible to you, Riddhi?
Yes, sir, you're completely audible and visible.
Fine, fine. So, as I was telling you, this concept of which is given under Article 21 is divided in three parts. Okay, first is called the procedure established by law. Second is called the due process of law, and in due process of law there are two concepts. One is the procedural due process of law and substantive due process of law, and we are going to see this. Okay, so let's begin with this. I just reminded of my yesterday's incident. I was sitting with my dog. Okay, my dog name is Disco, and yesterday when I was feeding my dog, it was 11 p.m. and since my dog had not eaten food, I was very angry on him, very angry at him. Now I gave him command that Disco, please eat now, it's enough. Okay, and it's 11 p.m. He was not ready to listen to me. He kept quiet and did not respond at all. I was shocked after seeing this, and I was again very angry. Then again I shouted at him and said, this is not the way, eat, eat, eat. He again did not respond to me. After that, I kept feeling angry at him. After that I realized that am I not interfering with the liberty of my dog to eat whenever it wants to? Whether this much interference from my side is justified, this much
Sir, you are
Sir,
muted.
you are not audible. Please switch on your mic.
Yes, just a minute. Yeah, am I audible now?
Yes, sir.
Okay, so I was on the point that yesterday I was feeding my dog. He was not listening to me. I was very angry at him. My object was to feed him properly so he can have good nutrition and all. But he was not ready to listen to me. So I got angry at him. Again after that he was not responding. So I kept getting angry at him, and after that I realized that whenever I'm telling him to eat, am I not interfering with his liberty to eat whenever it wants to? And whether this much interference from my side is justified. Kindly unmute everyone. Achal and everyone, please kindly unmute, okay? Because it breaks the chain. Okay, so my point was that whether I was not interfering with its liberty, because everyone has the liberty, even the animals have the liberty, even the human have liberty, the cats have liberty, the dog have liberty, everyone has liberty. Now, the question was whether I can punish him or withdraw my treat, the treat which I was going to give him after he finishes his food. I was going to withdraw that particular treat, okay, which I wanted to give him because it exercised liberty not to eat. Now, then I thought, what if the government had been in my place, and if I had been in my dog's place, and if the government had made such a law that in India everyone has to eat at least 3 times and before 11 p.m. okay, and otherwise if someone is not eating after 11 p.m. he will not be given food and he will be prosecuted. Think about that kind of law in your mind. That government of India is passing the law, legislature is passing the law and saying that everyone in India, children, the adult, the minor, they have to eat their food before 11 p.m. Otherwise the government will prosecute them, okay? Or else what will happen? So the question actually here is whether this kind of law, which is seizing the liberty, which is depriving you with the liberty, whether this kind of law is justified. Now, this kind of law, if you see, this is not a violation of Article 14 for now, because after that we will analyze many judgments. For now, it is not violation of Article 14 because it is not actually violating the equality principle. It is seeing everyone in the same way, that no adult is escaped from the law, no women is escaped from the law, no one is left out. Everyone has been included. So this question, if you look at this in present scenario, in present context, this particular law is not violating Article 14. This particular law is not violating Article 19 also. But it is violating Article 21. If you look at this, the question is whether it is violating Article 21. This can be the proper question here, okay? Now, there is no procedural defect in law. It gives all right of notice. Suppose if the law says that if anyone is not eating till 11 p.m., he will be prosecuted. Opportunity of being heard will be given to him. There are proper court which has been set up by the government. Everything is there. All the procedure is fair, just and reasonable. Everything is there. But at the last, it is depriving you of your liberty when to eat. So I'm not going to focus today merely on the procedural part of it, that whether the procedure is fair, just and reasonable. The law itself, if you look at this, the law itself is seeming unreasonable here, right? So this is one of the example. Another example, if I would like to give you to make this topic interesting, that if suppose government is passing the law that everyone, in 3 days they cut their nails. You all cut your nails, right? By the nail cutter. Suppose if tomorrow Parliament is bringing the law which is saying that everyone has to cut the nail by the scissor and not by the nail cutter. Okay, this is not violating Article 14 because there's no question of equality for now. No violation of Article 19. It's not freedom of speech and expression, something like that. Okay, but the question is, it is seizing your personal liberty under Article 21. This is another example. So if
Participants are requested to kindly mute yourself.
Ms. Kalgi, please unmute. Yeah, thank you. So I was on the point, if this kind of law is brought by the government, the question is whether you can challenge them under Article 21 of the Constitution of India. Again, I would like to give you one more example, and after that we will start analyzing the situation. One example is, which is very interesting, and I have so many people I have asked, but I have not got the answer for this. I hope that you will be able to answer that in the last. Suppose if the government, not suppose, government has passed in reality, the government has passed the Minimum Wages Act. I think everyone knew about the Minimum Wages Act. Everyone knows about it, the Minimum Wages Act, right? Minimum Wages Act fixes that someone whoever is working in the factory or under the employment, they will get the minimum wages. Suppose in a month 10,000 rupees, or suppose in a month 15,000 rupees, right? Analyze the situation where in a factory there were 500 people who were working. 500 people who were working. Till this time, the law had not been passed by the legislature, and the employer was paying everyone 3,000 in a month. Okay, and all the 500 people were happy about it. They were happy that okay, they are getting at least some money to survive themselves. But after some time, the Minimum Wages Act come, and after coming into existence, the Minimum Wages Act, the government says that the employer has to pay at least 10,000 rupees or 15,000 rupees to the employee. The employee now says that I'm happy with 5,000 rupees. Okay. The employer says that, see, when I will pay 15,000 rupees and 10,000 rupees to all my employee, it is not possible for me. It's not profitable for me at all. So what he does, rather than giving salary 10,000, 5,000 to each and everyone, he just fired his 400 employees. All 400 employees are fired, and he says that I will be able to take care of my company in this 100 employees. Those 100 employees files a writ petition, for example, in the Supreme Court of India under Article 32, that this Minimum Wages Act is in violative of their right to livelihood under Article 21 of the Constitution of India. What will happen to this? Now, earlier what used to happen, that suppose the employer is filing the writ petition under Article 32, all the employers are filing the writ petition under Article 32, that this law is invalid. This law is violating the liberty principle which is given under Article 21. But suppose in fictitious situation, the employees file a writ petition under Article 32 while stating that it violates our fundamental right to livelihood under Article 21. What will happen to this? What will happen in this kind of situation? How the court is going to come to the conclusion? How the court is going to make the balance, between the social interest and the social welfare legislation and the individual interest or individual liberty of right to enter into the contract? So in order to find the answer for all these questions, we need to understand few things. Okay, and we have to start from the scratch. Start from the scratch means from where it all began. So from where it all began, the question arises. So we need to look into the Magna Carta. Okay, the 1215, the Great Charter, it was known as. So the full name of the act was the Magna Carta Libertatum. I would like to share the screen so that you can see this. It was known as this Magna Carta Libertatum. Now what is this Magna Carta Libertatum? Magna means great. We use this word in English. Magna means magnanimous, the great. Then Carta means charter, and Libertatum matlab liberty. Libertatum means liberty. So the Great Charter of Liberty, and it was famously known as the Magna Carta. Now, this Magna Carta, what was the purpose of this Great Charter in England? So this was, signed in 15th June 1215 by King John of England. So what was the reason that it came? Just a minute. So what was the reason that it came into existence? There was in that time, in around 1215, there was a dispute between the Kings John II and there was a group of baron. Baron, what is the meaning of baron? Baron is, in that time, who were the landowners, the aristocrat people, the very rich people, who by heredity used to get the property. So in that time, there was a dispute between barons, aristocrat, the landowners, and the King John II. So King John II, the executive in that time, in today's context, if you see the police. So the executive that time, the King John, merely by its own order, used to imprison these barons. Okay. He used to give order for the imprisonment of this baron. So there was a lot of dispute between the group of barons and the King John II. Now, after that, King John II was forced to sign this charter, which made it that no free man shall be taken or imprisoned unless by the judgment of peers or the law of the land. So now note down this word. The law of the land is very important word here. Okay. This law of the land, this word is very important. So what this charter was saying, this charter made it very clear, no free man shall be imprisoned or shall be taken unless by the judgment of peers or the law of the land. Okay. So it was a very, very great charter which gave people in that time liberty. And this, the importance of this charter is that still it is being taken into consideration even by the Puttu Swami judgment, Justice Puttu Swami judgment, which was passed by the 9 judge bench of the Honorable Supreme Court. I'll come to all these points later. So this Magna Carta, after some days when Pope Innocent III came, he annulled this particular charter, Pope Innocent III, and this led to First Baron War. Okay, it was very famous war, and after that, from 1200 to this 1600, again there was conflict. People used to be imprisoned simply, no following of this due process, no following of this the law of the land. Nothing was there. Then after that, in 1610, there was a petition of grievance. Just remember this, if you are making notes, keep writing the notes, and then after that we will analyze the point, because before knowing the history we can analyze the points or the question which I just gave you. So in 1610 there was a petition of grievance, and after the petition of grievance there was a petition of right. You might be knowing the bills of right. Okay, and the bills of right came in 7th June 1968. Okay, and this bills of right 1628, not 1928, this 1628, 7th June 1628. And this bills of right or petition of right was an English constitutional document. It was similar in the terms of the Magna Carta. Okay, so this bills of right, what they used to provide, they were saying the ultimate object of the bills of right was that we do not have any problem that if you are being imprisoned, we do not have any problem with that. But if you are imprisoning, if you are detaining us, detain at least by the common consent in Parliament, by the consent of the legislature. Okay, so what it says that there are certain rule of law, and not we want to be governed by certain rule of law and not by the arbitrary form of government. So people can be subject to punishment only when ordained by the law of the land or by the statute made by their common consent in Parliament. Okay, now this observant of this period has brought the rule of law in England. Everyone, we read the rule of law. We read the rule of law, right? So this concept brought the rule of law in England. After that, in the time of King Edward III, in USA in 14th century, they first time brought this concept, the due process of law. Okay, but the due process, so the ultimate, if you look at this, how USA has got the this due process of law, they had taken from the Magna Carta and or the, if you say, the bills of right, which was there in 1628. But there was a difference. Now this is the interesting point. There was a difference between the law of the land, which I told you, I just asked you to mark, the law of the land, and the due process of law in USA. What was the difference? So that, and it has a great connection with Article 21, which I'm going to teach you after some time. So the law of the land says that if a state is depriving the liberty of the people, the life and liberty of the people, but if the Parliament has made the law, then it means once there is a law passed by Parliament, any punishment can be given. Understand this. Suppose if the Parliament has come up with the law that that everyone who has the green eyes will be killed. So the law in England was, okay, that's fine. If Parliament has brought the law, that is fine. If the procedure is there, everything is fine. Now what they used to say, that we do not want to be prosecuted merely on the discretion of the government, merely on the discretion of the executive. So what they wanted in England, that there has to be some law passed by the Parliament. Once the law passed by the Parliament is there, the gap has been filled. Okay, remember this, when I'll teach you the procedure established by law, it has a similar meaning. So the law of the England is, once the Parliament law is there, any liberty can be seized. So there was no, there was no guidelines on the factor or the discretion of the law made by the Parliament. Okay, whatever has been made by the Parliament was fine. But in USA, the due process clause used to say that even the law which has been made by the Parliament, they also has to be fair, just and reasonable. They cannot be unreasonable. Like I told you, that if suppose the parliament is passing the law that you have to cut your nail by the scissor and not by the nail cutter. This is your personal liberty. This cannot be questioned in UK, but this could have been questioned in USA. Why? Because in USA there was a due process clause. Okay, they, on the basis of due process clause, they even used to limit the power of the parliament to bring the law. Okay, so I will give you another example. If a statute in UK, if the statute does not authorize the arrest of a person without warrant, executive cannot do so. That's fine. But if parliament have brought the law that executive can arrest anyone and can seize the property without warrant, then in UK that is fine. But in USA, court will even go to check the competence of the parliament to pass that particular law, that whether it is not against the liberty of the people. So this is the difference between the law of the land, the word which I mentioned, which was there in the Bills of Right, and the due process clause, which was there in the USA in the King's this Statute of Edward III, EDWARD, Edward III. Now, there was a great author and critic in 18th century. His name was Leslie Stephen, Leslie Stephen, Stephen. Okay, he said that in England the situation was like that if a legislature decided that all blue-eyed babies should be murdered, if legislature has decided that all blue-eyed or green-eyed baby had to be murdered, the preservation of all blue-eyed babies would be illegal. So in simple, there is no protection for the people against the law made by parliament in England if the law derives, even if the law deprives people of their life and liberty. But so what was the position in UK? Liberty was always confined to the law made by parliament. But in USA, what was the position? Due process clause even used to limit the power of the parliament to deprive people of their right and liberty. Now, in 1776, now from 14th century and the critique which was I told you by the Leslie Stephen, we are now again coming back to 1776, and the date was July 4th, 1776. And there was a historic American Declaration of Independence. I think you might be knowing, there have been many movies also in this American Declaration of Independence. Now that American Declaration of Independence made it very clear, and it made it clear that there are certain inalienable rights. What is the meaning of inalienable? Which cannot be alienated, which cannot be separated. So this American Declaration of Independence pointed out that there are certain inalienable rights, and those, what are those rights? Those are life, liberty, and pursuit of happiness. And then it says, if government, the purpose of constituting the government is to secure that right, to secure that particular liberty, and the time government has started breaching that particular right, government has started violating that particular right, it is the right of the people to change the government. It is the right of the people to alter it and abolish it. So you will find out that from there, in USA, the concept of liberty is very, very wide even compared to the India. I will come to that part later, and even compared to this England part. So the view of liberty was very, very wide. Okay. Then in USA, we need to remember two things. First is Fifth Amendment in USA and the 14th Amendment in USA. What is that Fifth Amendment in USA? Fifth Amendment says, like in India, we have Article 21. In USA, it has Fifth Amendment and 14th Amendment. Fifth Amendment says, no person shall be deprived of his life, liberty, or property without due process of law. Okay, so there are three words which was used in Fifth Amendment. What is that? Life, liberty, or property, and fourth is without due process of law. 14th Amendment USA also says the same thing. Now these two amendments basically known as the due process clause. Okay, so in England, all the parliaments enacts is the law of the land, but in USA, how they are governed? They are governed by the due process clause. Now we need to understand at this stage, at this juncture, that what is the meaning of procedural due process, because I told you the due process is divided in two parts, procedural due process and substantive due process, and this is where we get confused. So we need to understand what is the procedural due process. So as I told you, if parliament is passing the law, okay, that whoever commits theft, they have to be hanged in the square, they have to be hanged in the district, suppose at 12 o'clock at night. Suppose if this kind of law which has been made by the parliament, just take a fictitious example for now. Now, if the law is providing you all the opportunity of being heard, the law is providing you the notice, the law is also providing you the right of cross-examination, the law is also providing you and giving you a chance of the presumption of innocence, it is also providing you the orderly course of procedure, it is providing you all the procedure which is fair, just and reasonable. Okay, but ultimately it is wrong. But what is the meaning of procedural due process here? If in any constitution there is only a procedural due process, then what will happen? Court will not take into consideration the unreasonableness of the law. So suppose if as I told you, law says you will be hanged till death if you are merely found with committing theft. You will be hanged till death. Court will not question that merely giving death penalty for small act of theft is right or wrong, reasonable or unreasonable, arbitrary or non-arbitrary. Court will not consider that. Court will only look into the procedural due process, that whether the person whose liberty is being deprived, whether he is being given the due process, whether he's being given the right of being heard, whether he's being given the notice opportunity, charge freeing opportunity, and so on. Okay, now look at the meaning of substantive due process. I hope everyone has understood the meaning of procedural due process here. Okay, that procedure has to be fine, procedure has to be fair, just and reasonable. If suppose at this situation the law had not provided you the opportunity of notice, opportunity of being heard, and so on, the right court, the partial court, suppose court had the law had provided you, in that time you could have raised the objection that this is not a procedural due process. Okay, so procedural due process only concerns about the procedural part of the law and not the substantive part of the law. This is the procedural due process of law. Now in substantive due process of law, there are various angles of substantive due process of law. So for example, I have still not come to the Indian part. Okay, I have yet not come to the Indian part. I'll come to that part later. First, I'm in the concept that how it started. So in the substantive due process, there are multi-variety of it. So first example is that if the law is vague, if the law is so vague that a person is not able to understand that what conduct is lawful and what conduct is not lawful, and it leaves everything upon the executive or the court to decide in each case. In that time, if you look at this, the whole law itself is vague, not the procedure. Procedure is fine, but whether you have the citizens, the people who are governed by that law, they are not able to come to the point that the act which they are doing is legal or the act which they are not doing is legal. So they are not able to justify between these two kind of conduct. So the courts in USA used to say that this particular thing is very vague, and the time it is vague, the law has to pass the test of substantive due process, and on the basis of substantive due process, the court in USA used to struck down that particular law. Okay, so first example of the substantive due process is vagueness. Second point I would like to tell you is that now when the law is so broad that it punishes the person for exercising his fundamental right, then it will offend the substantive due process. For example, I would like to give you one example in USA. So first example is the case known as Coates versus Cincinnati, COATES versus CINCINNATI, 1971, 402 USA. So the recent judgment only of 1971. Now in this case, what happened, that law was made in US that if 3 or 4 persons are assembling or they are gathering on public place and their conduct is such like that the people are getting annoyed by that particular conduct, okay, then it used to detain people, it used to provide punishment to the people. So for example, if I'm standing in public park and if I'm doing something and if the people are being annoyed, the law used to say that I can be punished for that particular thing. Now the matter was challenged in the US Supreme Court, and the Supreme Court said that this word annoyances is very vague because it is very subjective term. There are few people who cannot be annoyed, you do whatever you do, but there are certain people who can be annoyed in very small things. Everyone may have the experience sitting here. So court said that annoyance depends on person to person, it is very subjective term. So court said there are certain liberties which are specifically mentioned in the constitution, but there are some liberties which are not written, which are unwritten. So for example, in India, if you say in India, if I talk about, there are few liberties which are given in the constitution. For example, under Article 19, freedom of movement, freedom of speech and expression, all are the liberties. But there are few liberties which are not provided in the constitution. For example, right to marry, okay, right to have children, right to move interstate migration, okay, right to have children, right to have how many children I want to have. All these are the liberties which are not expressly given in the constitution, but they are unwritten. How they have come? Through the judgments of the court. Okay, so let me conclude, let me say this, that the substantive due process, if you look at it, is divided in two parts. First part is called the first era. If I mention, it's called the Lochner era. Okay, so where court invalidated the economic regulation covering private property and contract, as court considered that they were against the personal liberty to contract. Okay, what I'm trying to tell you with this is this. As I gave you the example of Minimum Wages Act. So in USA also, there were Great Depression. When there was a Great Depression that time, USA brought many law like this, which used to govern the working hours, which used to govern the minimum wages, or it used to regulate the salary of the employee, that at least minimum you have to provide this. So the employer in USA challenged these particular social welfare legislation in USA, and they said that it is against our liberty to enter into a contract. Okay, so the court, on the basis of due process clause, invalidated those social welfare legislation, and this was a very big danger. You need to remember this point which I'm telling you in order to understand future the concept. Okay, so what court said in USA? That court invalidated these particular social welfare legislation, and which left a long lasting impact on the mind of the jurist, that why court is striking down these social welfare legislation. Okay, so one concept was confining to the liberty of the people to enter into a contract, and it is known as the Lochner era, Lochner, Lochner era. After that, so now the Lochner era does not exist. There is a second era now, and the second era was which used to say that court invalidated the law where government interfered with the intimate relationship. Intimate relationship means, suppose government is interfering my right to have food at whatever times I want to. Government is interfering with my right to marry. Government is interfering my very small things, scissors and the nail cutter example which I give you. It is called the intimate relationship. My right to autonomy. So this particular substantive due process is still continuing. So again, I am telling you, it is divided into two parts. First era is my liberty of entering into a contract which does not exist. Second is my liberty which is confining to the intimate relationship. Okay, now it is continuing. Now I would like to come to the Indian perspective. When you have read this about these two eras, in Indian Constitution, if you look at, Article 21 provides that no one shall be deprived of his life and personal liberty except the procedure established by law. So if you look at this, there are three very important words which has been mentioned here. Even four: deprivation, life, liberty, and procedure and law. There are four to five very important words. Now, if you look at the Constitutional Assembly draft for this, we need to understand this and analyze this Constitutional Assembly debate before we go to the Supreme Court judgments, that how court has been interpreted these concepts. So in Constitutional Assembly debate, the first draft of Article 21 was put forth by Dr. V.R. Ambedkar. Okay, and the clause was something like this. The draft which was put, it was something like this. I think everyone is able to see this. So a state shall deprive any person, a state shall not deprive any person of life, liberty and property. This is important. And the due process of law. This is important. So in Indian Constitution also, the Constitutional Assembly first time brought this particular clause, and this was taken into consideration by this was put forth by B.R. Ambedkar. If you can see this, here the word liberty is mentioned, and there is no word personal like you find in current Article 21. Let me put here Article 21 also. See this. This is current Article 21. Now you can find out the difference here. यहाँ पर अगर आप देख रहे होंगे, here if you are able to see liberty, the word is personal liberty is mentioned. The due process of law, procedure established by law is mentioned. Now how this came? Let's see this. So if you read the entire judgment of this Justice Puttaswamy judgment of right to privacy and many other judgments, you will find that there was a person known as, and he was a great jurist known as the B.N. Rao. You might have heard his name. He was advisor to the Constitutional Assembly, okay, and his full name was Benegal Narsingh Rao. So what happened that time, that he used to go to different countries to take the suggestions for putting in Indian Constitution. Okay, he used to visit different countries, England, USA, and in USA he met Justice Felix Frankfurter. Whom he had met? Justice Felix Frankfurter, and Justice Frankfurter advised him not to use this due process of law clause. So it was the advice which was given by Justice Felix Frankfurter in USA not to use this particular word, due process of law. Why he used? Because he says that once the Indian Constitution uses this word, due process of law, it will be divided in two parts, the procedural due process and substantive due process. And since he was the judge of American Supreme Court, he had known this, that on the basis of substantive due process clause, many social welfare legislation in USA had been invalidated. So once you bring this particular clause in India, you will not be able to pass any law which is in the welfare of the society, which is the social welfare legislation. So for example, the Consumer Protection Act, the Minimum Wages Act, and all the labor legislation, you cannot bring it. Why? Because everyone will come and they will say that it's my personal liberty to enter into the contract. It is my personal liberty to sell any product in any price. Suppose in now you have the MRP. Okay, now this PVR, Inox, when we go to watch movie, they cannot sell something beyond MRP. Okay, you have read so many judgments and order like that. But suppose if the word liberty had been there, like it was there when the Constitution was being drafted, and if the word due process of law had been there, you will be surprising to know that these social welfare legislation had not been existing in India. Okay, and I'll come to that particular part later. Okay, so he advised Felix Frankfurter advised B.N. Rao that not to put this particular clause. And he gave the example that in USA only between the period of 1899 to 1937, US Supreme Court had struck down 159 social welfare legislation, 159 statute. And under 5th Amendment clause and under 14th Amendment, the Supreme Court had struck down 25 other statute. So many statute were struck down by the US Supreme Court. Now, as I told you, this was instilled in the mind of the framers of the Indian Constitution that once you are using the word liberty is very wide word. Okay, suppose if I am burning some garbage outside of my room or outside of my house and someone is being annoyed by this, okay, that you are creating pollution in the environment, what I will say it is my liberty. So the time word liberty had been there under Article 21, it would have been very wide. So what the framers of the Constitution, what was the first thing they did? They said, no, you do not have the absolute liberty, but you have the personal liberty. Okay, and this personal liberty is subject to the procedure established by law, which we are going to come to the later stage. So first you need to understand the meaning of word liberty. Liberty is personal liberty, and it is not very wide liberty like the civil liberty what the US people enjoy. So in liberty, we have very limited liberty under Article 21, which was brought by the framers of the Constitution. Okay, now this was again, I'm not going to how Justice Frankfurter got influenced by Bradley and all. I'm not going to go to that. Now in Constitutional Assembly, the members were divided in two parts. How they were divided? One group of the members of the Constitution Assembly were saying that this due process of law is fine. Why it is fine? They were saying that parliamentarians, the member of the parliament, they are also human and they can also create mistakes. the time they create mistake, the time they come up with the unreasonable law, the judiciary should be there to take care of them as a guardian of the constitution. So what judiciary will do? Judiciary will correct the law. Judiciary will make that law reasonable. Okay. But there were other group. The other group used to say, the other group of the Constitution Assembly, they used to say that if this much power is given to the court, what will happen? There are so many member of parliament, right? There are so many member of parliament. Once they are passing the law, you are giving the unnecessary discretion to the 4 to 5 and 6 gentlemen which are sitting in the Supreme Court. This word was used, that you are giving power to the few gentlemen which are sitting in the Supreme Court, and they will turn down the law. So there were two views like this, and all these view in the Constitutional Assembly was concluded by Dr. B.R. Ambedkar in one paragraph in the Constitutional Assembly, that one view is like this and one view is like this. Now, the B.R. Ambedkar did not say anything in this particular point, and he referred this particular word. He says that it is a case because one side is the parliament and another side is the judiciary. If they are giving power to this side, this power will, the judiciary power will go down. And if they are giving more power to the judiciary, the parliament power will go down. So they says, the B.R. Ambedkar says that he do not want to proceed with this. He do not want to sail with this particular point, because he said it is like sailing between Scylla and Charybdis. This was the word Scylla, Scylla, and Charybdis is Charbydis. Scylla and Charybdis. Scylla and Charybdis, if you read in Google, you will find out that there were two monsters in Greek mythology. Okay, in Greek mythology there were two monsters. So if you are passing through this particular way, if you are going towards Scylla, the Scylla will eat you, and if you are going towards Charybdis, the monster Charybdis will eat you. So B.R. Ambedkar says that I do not want to go either side, because again both sides I am seeing the danger. Okay, so he did not refer to anyone, and he said, let the Constitutional Assembly divide. I do not want to give my view. And finally, Constitutional Assembly deleted the word or the expression due process of law. They finally deleted it, and they rather brought Article 22 to provide the procedural safeguard in the case of arrest and detention, that if anyone is being arrested, he will be provided with the grounds of arrest, the reason for arrest, and so on. He will be producing before the magistrate within 24 hours. And all these provisions were brought under Article 22. But the due process clause, which is there in the USA, it was deleted. Now we come to the judgment part of the Supreme Court, which was passed by the Honorable Supreme Court of India. And the first judgment, now the boring part of the history has gone, everyone. So now, from here, the first case was A.K. Gopalan versus the State of Madras, which came in 1950. Who was A.K. Gopalan? A.K. Gopalan was a communist leader. So in that time, there was a preventive detention law. Okay, the legislature had come up with the preventive detention law, and the power had been given to the central government or the state government. What kind of power? That you can prevent people and you can detain them. So in the similar way, the communist leader, Mr. A.K. Gopalan, was detained in jail. Okay. With that, he filed a writ petition before the Honorable Supreme Court of India under Article 32, the writ of habeas corpus. And he said this preventive detention law is violative of Article 14, 19 and 21 and 22 of the Constitution of India. In this judgment, there were two questions which were framed by the Honorable Supreme Court. What were these two questions? First question was that whether one fundamental right can be read with other fundamental right. What was the exact question? That whether one fundamental right can be read with other fundamental right, or I can say that whether fundamental right has to be read in a watertight compartment. This was the language which was used in framing the issues in A.K. Gopalan case. That whether fundamental right has to be read as a watertight compartment like this. They cannot go like this. It means you cannot read Article 19 with Article 21. You cannot read Article 21 with Article 14. This interconnection reading you cannot make. So this was the first question, that whether it is possible. Second question was whether this procedure established by law under Article 21 is a due process of law. Whether in India under Article 21 we are following the due process of law or a procedure established by law. So this judgment was decided by the 6 judgments, like Not like today, we have 5 judge bench, 3 judge bench, 7 bench or 9 bench. No, in 1950 it was decided by 6 judge bench. And all the judges framed their separate opinion. I would like to tell you here about Justice Fazal Ali. Justice Fazal Ali in A.K. Gopalan case gave the dissenting opinion. So first understand what majority says. So majority says that no, you cannot read one fundamental right with other fundamental right, and every fundamental right is separate, and you cannot create the thread of these article 19, 21 and 14. They said no, the constitution framer never wanted that. With regard to the second question, majority says that due process of law was neglected by the Constitutional Assembly, and the procedure established by law is that once there is a procedure which has been framed by the parliament, your right has gone. So your right, what majority says actually in A.K. Gopalan case, that the time you have right, the time you have the right only till the time parliament makes the law. So the time parliament has made the law, the gap has been filled, and parliament can take away any of the rights which you have. Okay, so article 21, majority interpreted that no one shall be deprived of his life except the procedure established by law. So once the procedure is there, your life and liberty can be deprived. But Justice Fazal Ali was not in consonance with this particular opinion. And I would like to tell you that he gave the dissenting opinion in that particular judgment. Also, one of the important thing I would like to tell you about Justice Fazal Ali, and it is very interesting, that he spent 2 years in Supreme Court, and out of 2 years, he spent 8 months as an ad hoc judge. And in these 2 years, he had given 6 dissenting opinion, and out of 6 dissenting opinion, 3 became the law in future. 3 became the law in future, and 2 opinion and in this particular judgment, Justice Fazal Ali gave the dissenting opinion, and this became the law in Menka Gandhi case. So what was the dissent which was given by Fazal Ali? Fazal Ali did not agree with the majority, and he said sorry. He analyzed all the Magna Carta, which I just told you. He analyzed all this Statute of Edward III. He analyzed the Bills of Rights of 1610, 1628, American Declaration, French Declaration, and everything, all the International Charter and all. And then he came to the conclusion that no, procedure first, with regard to the first question, he said that one fundamental right can be read with other fundamental right. Otherwise, it will be infructuous. It will not make any sense. So he said that one fundamental right fertiles the other fundamental right. Article 19 can be read with Article 21. Article 21 can be read with Article 14. And this law, this dissenting opinion of Justice Fazal Ali was taken into consideration in R.C. Cooper versus Union of India in 1970, and it became the law. After so many years, after around 20 years, it became the law. And then, with regard to the second question, he said that no, the due process of law meaning is the procedure established by law meaning is the procedure which has to be fair, just and reasonable. It means the substantive procedure, the procedural due process of law. So what Justice Fazal Ali said, that procedure established law means procedure, the procedural due process of law. Okay, so merely Parliament is coming with law and it is filling the gap, it will not be sufficient. The Parliament has to provide the fair procedure, the just procedure and the reasonable procedure, and it has to be checked by the court. How court will check? Suppose if the Parliament has come up with the law, any procedural law which is depriving the right of the people, court will go to see that whether it is fulfilling the objective of the reasonable restriction also which is given under Article 19. So suppose if Parliament has come up with any law which is depriving the liberty under Article 21, that particular law not only has to fulfill the requirement of Article 22, but also it has to fulfill the requirement of Article 19 also, the public interest, all the reasonable restriction, the proportionalization and everything it has to bring. It also has to be read with Article 14, so it also has to fulfill the objective of Article 14, the reasonableness which is given in Article 14. So according to Justice Fazal Ali, the procedure established by law is a due process of law. But in that time, his view was not accepted, and it became law in 1976 in Menka Gandhi versus Union of India. So in Menka Gandhi versus Union of India, I'm just coming to 1976. The Supreme Court 5-judge bench held that the procedure must be fair and just and reasonable. Any procedure which is depriving any liberty has to fulfill the test of Article 19. any procedure which is depriving the liberty has to fulfill the test of Article 14 also. Okay. Now after that, we directly come to the case of Sunil Batra versus Delhi administration in 1978. In this judgment, Sunil Batra versus Delhi administration, there was section 30 subsection 2 of Prisoner Act. So before that, I hope you have understood that how the dissenting opinion which was given by Justice Fazal Ali was upheld in Menka Gandhi case after so many years. So Justice Fazal Ali was way ahead of his time in framing the law, in seeing the things clearly, the picture of the democratic process. Okay. Now in Sunil Batra versus Delhi administration in 1978, 4 SCC page number 494, if you want to write down the citation, the question was with regard to section 30 subsection 2 of the Prisoners Act 1894. Now what was that section 30 subsection 2 of the Prisoners Act? It used to say that prisoner who are under sentence of death, any prisoner who is under sentence of death, they have to be kept in the solitary confinement. You have read that this case is for the solitary confinement. So this case was in relation to section 30 subsection 2. What it used to provide, that any prisoner who has been given the death penalty, they have to be in the solitary confinement. And this particular provision was challenged in the Supreme Court. Supreme Court did not strike it down, but Supreme Court held that, Supreme Court read it down. And Supreme Court held that the word sentence of death, जो दिया हुआ है word यहाँ पर sentence of death, it would apply only after the entire process of remedies had been exhausted by the convict. Okay, suppose when he had applied for the Supreme Court, or suppose if the death punishment has been given by, the death penalty has been given by the district court. So Supreme Court in this judgment says that merely if he has been given the punishment of death sentence by the district court or by the high court, he cannot be kept in the solitary confinement till the time he has exercised all his remedies. So for example, if he had appealed in the High Court also has confirmed it. If he had filed an appeal in Supreme Court has also upheld it. Then he had applied for the clemency petition, and the clemency petition has already been decided. In that time only he will be kept in the solitary confinement. So court in this case said the procedural law should be fair, just and reasonable. It relied on the Menka Gandhi case. Now the next judge, so if you look at here, all the judgments which are coming, they were focusing on the procedural due process of law. That procedure has to be fair, just and reasonable. They were not saying anything about the law point, that whether you can challenge the law itself. But they were focusing on what point? That procedure has to be fair, just and reasonable. So now, as I gave you the example, if Parliament is passing the law which is saying that if you are caught with committing theft, you will be hanged till death in the square or in any town, something like that. Okay, you cannot challenge the whole law, but what you can challenge, the procedure which has been provided. If there is no opportunity of being heard, if there is no notice, that particular law can be challenged, but not the substantive part of the law. You cannot challenge the substantive part of law under Article 21. But in later stage, in Bachchan Singh versus Union of India, the substantive challenge, Bachchan Singh versus Union of India, came in 1980. And in Bachchan Singh case, substantive challenge to the constitutional validity of the statutory provisions which gave the death penalty under under section 302 of Indian Penal Code, all these death penalty was challenged. Okay. Now court in this case said that not only the procedural provisions has to be fair, just and reasonable, but also the substantive provision has to be fair, just and reasonable. And court again read it down. Court did not strike down the death penalty clause, and court read it down, and court says that the death penalty has to be given in the rarest of the rare case. Why court said so? Court said that the procedure or even the substantive part of the law, now we are coming to the substantive due process of law, step by step. Okay, court said that even the substantive part of the procedural law has to be fair, just and reasonable. And after this judgment, very important judgment in relation to substantive due process, which was Mithu versus the state of Punjab. I think everyone may have studied this when they were studying IPC. In this case, court struck down section 303 of Indian Penal Code. Why court struck down? So this was the judgment which was given by the Constitution Bench, and in this judgment, Constitution Bench considered the validity of section 303 of Indian Penal Code. Section 303 provided mandatory death penalty, that suppose if someone is under already life imprisonment and if inside jail he's committing the murder, then compulsory death, this life imprisonment, the compulsory death penalty was there under section 303. And for that, the procedure was, what was the procedure? That he will not be given any opportunity of being heard. Okay. So in general, if you are being given any punishment, there is an argument on sentencing. You say that, my lord, I should not be convicted for, I should not be given the punishment of 10 years, I should be given the punishment of 7 years. If the minimum punishment is 7 years, maximum is 10 years. You argue like that in the court, right? But under section 303, it was a compulsory death penalty. It means you will not be given an opportunity of being heard to argue before the court that why you should not be given death penalty. So court said in this case that not only the procedural part of CRPC, which is provided under section 235 subsection 2, which talks about the opportunity of being heard on the arguments of sentencing and so on, court said that even substantive part of the law which is provided in section 303 is unconstitutional. So this is the judgment where court not only struck down the procedural part, but court struck down even section 303, the substantive part of the law. Why? Because it was depriving the person, article, not only article 14 but also article 21, the liberty, right to life and liberty. After that very important judgment, I'm directly coming to Muhammad Arif versus Supreme Court, Registrar Supreme Court of India. And this is the judgment which was passed by the Honorable Supreme Court in 2014. Okay. And in this judgment, the Constitution bench, actually, I'll tell you first before I delve into this particular case, I would like to tell you one thing. When you file, suppose if your SLP has been decided in Supreme Court, or if Supreme Court has given any judgment, you do not get the review petition, the oral hearing in the review petition generally. Okay. Judge decide the review petition in his chamber. So any judgment, if it has come against you, we file the review petition in the Supreme Court, and Supreme Court does not give the oral hearing. There is no argument in the review petition under Article 137. Court decided in this chamber, and if court thinks that oral hearing should be given to you, they will again take it back, their judgment, and they will say that now you can proceed. But there is no right per se for the arguments in review petition. So this was the question in Muhammad Arif versus Registrar Supreme Court of India, that whether oral hearing of review petition when there is a death penalty has been given to the person, whether the oral hearing is a right. So Constitution bench in this court said that the procedure which is given under Article 21, the expression reasonable procedure in the context of Article 21, would encompass an oral hearing of review petition rising out of death penalties. So court in this case traced the entire history of Magna Carta, of the A.K. Gopalan case, the Statute of Edward III and so on. The judgment was dictated and the judgment was given by Justice Rohington Nariman, and he said, this was the word which he has used, this was the expression which he had used. He said, the wheel had turned full circle, and the substantive due process is now to be applied to the fundamental right to the life and liberty. Okay, till now the substantive due process was not there, but from this judgment court had said that now the wheel has taken the full circle and substantive due process is a part of Article 21. Okay, but which substantive due process? Not the first era of substantive due process, which when I was teaching you, the Lochner era, which I told you there are two kinds of substantive due process, which govern the liberty of the person to enter into any contract, and second, which govern the liberty of the person for its own, the personal liberty wala part, right? So court in this case said the substantive due process is there. For what part? The second part, not for the first part. It means if anything is in relation to the personal liberty, not in relation to enter into a contract, but in relation to right to marry or something like that, death penalty and something like that, you have the substantive due process under Article 21. But again, there was a twist in. Okay. Again, after that, Supreme Court, there was a twist. In the case of Rajbala versus State of Haryana in 2016, Justice Chalameshwar again delved into the entire analysis of the Constitutional Assembly debate, and he put the caution that substantive due process of law was not accepted by the Constitutional Assembly. So when there is a substantive challenge to the law, we cannot use the word substantive due process of law. That is different. Substantive challenge to the law is different and substantive due process of the law is different. This was again held in Rajbala versus State of Haryana. And after that, Justice K.S. Puttuswamy versus Union of India judgment came 2017, volume 10, SCC, page number 1. And if you want to read about the substantive due process, you can go through this from para number 273 onwards. Para number 273 of the SCC copy, not AIR copy. And in this judgment again, the paras which I am referring you was analyzed by Justice D.Y. Chandrachud, and he analyzed everything and he gave very important point. He said that the word substantive due process is still not applicable in India, but he made this very important line, and he said that law is open to substantive challenge on the ground that it violates fundamental right, but they cannot be considered as substantive due process. Now understand this, I'm giving the time in this, okay? On one side there is a substantive due process, on the other side substantive challenge to the any law. So there are two types of challenge. One is a procedural challenge under Article 21. Then on another side there is a substantive challenge to the law under Article 21. I have already taught you that in Menka Gandhi case, the 5 judgments had already held that one fundamental right has to be read with the other fundamental right. So Article 21 has to be read with Article 19, has to be read with Article 14, 22 and so on. One fundamental right can be read with other fundamental right. So Justice D.Y. Chandrachud in this case concluded that no doubt Menka Gandhi case is saying so, no doubt Bachchan Singh judgment is saying so, but he said many of the judgment has misinterpreted the substantive challenge to the law as substantive due process of law. So he said in India it was completely neglected by the Constitutional Assembly, and no doubt you can challenge the substantive part of the law, but we cannot call it a substantive due process of law. Okay. But according to Justice Rohinton Nariman, because he was also part of the bench in this judgment, he again said that substantive due process is a part of in this Indian Constitution. So again, even after the Puttuswamy judgment, the doubt is still there that whether substantive due process is a part of Indian Constitution or not. But let me clarify one particular point here, that again I would like to go to one more judgment of MC Dovell. It's called State of Andhra Pradesh versus MC Dovell and Company. And before I go to this judgment, I would like to come to my questions which I asked you. The first question which I asked you is, what if Parliament is framing any law which is very unreasonable in nature? Like it is coming with the law that everyone in India has to eat food within 11 p.m. in night, otherwise they will be prosecuted. What will happen to this law? Can you challenge it now under Article 21? Procedure is fine. The separate tribunal has been framed. You have the absolute presumption of innocence. You have the right of cross-examination. Every right, procedural right you have. But if you look at this, is it not affecting your right to liberty? Fundamental right to liberty, prima facie. Is it not affecting your right to autonomy? So now the question is, this law can be challenged under Article 14 of the Constitution of India, not under Article 21, 14 of the Constitution of India, in the light of Menka Gandhi versus Union of India. How will you say so? Because any law which is coming now, what Menka Gandhi judgment says, one fundamental right can be read with other fundamental right, 14, 19, 21, all this golden thread. So if any law which is so unreasonable and any law which is so arbitrary, any law which is so unreasonable and so arbitrary, it can be challenged under Article 14 of the Constitution of India. Earlier, Article 14 was only confining to the equality part. Now you will say, sir, how it is violating Article 14? Article 14 only talks about the arbitrary, this Article 14 only talks about that a state shall not deny anyone equality before the law and equal protection of the law. It is only confining to the equality part. In present case, there is no violation of equality. Fine. But Article 14 ambit has been increased now. Okay, all this principle of reasonable classification, all these are there. But even if any law is arbitrary, mere arbitrary, any law is unreasonable, that law can be struck down under Article 14, read with Article 21 of the Constitution of India. Why I am saying so? Because there was a judgment, State of Andhra Pradesh versus MC Dovell and Company, 1996, 3 SCC page number 709, if you want to write down the citation. In this judgment, the court, the matter was there in the Supreme Court, full bench decision was there, 3-bench decision was there. Justice Nariman, who is the present Supreme Court judge, he was the arguing counsel in this case in the losing side. So he said that due process of law is a part of now Article 14 of the Constitution of India, and he said that merely if any law is unreasonable, that can be struck down under Article 14. But that time his argument was not accepted. In that time he was a counsel in the Supreme Court of the losing side. Supreme Court says, so sorry Mr. Nariman, we are not going to agree with you, and you have to prove the equality principle under Article 14. Okay, but after so many days, after 33 years, Justice Nariman became the Supreme Court judge. The case was Shaira Banu versus Union of India and others, 22nd August 2017, triple talaq case, which you know. Okay, the judgment was given by Justice Rohinton Nariman, and Justice Nariman, who was the counsel in that case, losing side, he overruled State of AP versus MC Dolan and Company. He overruled it, and he said no, and he gave proper reasoning for that. He analyzed again Magna Carta, Statute of Edward 3, everything he analyzed, and he says that why due process of law, substantive due process of law, is a part of Article 14, 21 and 19 of the Constitution of India. And he says that if any law is unreasonable or arbitrary, then also it can be challenged under Article 14, and you don't have to go for this reasonable classification principle and so on. Okay, so as in law we says that have patience, your time will come. Okay, so after 33 years, Justice Nariman, who was losing side, he overruled that particular judgment after giving proper analysis, and it was a wonderful judgment if you read this triple talaq case. So I would like to conclude this now. I gave you three concepts. Procedure established by law. If you go by the literal meaning of procedure established by law, it means once the procedure is there, your rights can be taken away by the parliament. You do not have anything to say. Second thing is procedural due process of law, which was there from 1950 till 1976, and still it is going on. Okay, Menka Gandhi case. It says that procedure has to be fair, just and reasonable. You cannot just simply bring the procedure. And now there is still a substantive due process. Substantive due process says that you cannot just simply bring the law like cutting the nail, passing the law, cutting your nails by stopping people, cutting the nail by scissors or by the nail cutter, kind of. You cannot bring that law. The law is unreasonable. That can be challenged under Article 14 of the Constitution of India, rather Article 19 and 21. So this is the concept now. Substantive due process again is confining to only law part of Article 21, and that law has to be tested with Article 19 and 21 of the Constitution. And procedural due process is confining to the procedural part. So there are many times that in UPSC the people have got the question, and in judiciary the people have got the question that whether in India we follow the substantive due process, whether we follow the procedure established by law or due process of law. Many people write that we follow now the due process of law, but there is no proper justification in the answer. So I hope after hearing today's session, analyzing all these points, you know what is procedure established by law, you know what is due process of law, and what is procedural due process. That procedure has to be fair, just and reasonable, notice, opportunity of being heard, proper court, impartial court, tribunals, and then there is a substantive due process. Substantive due process means law has to be reasonable, fair, just and reasonable. So not only the procedure has to be fair, just and reasonable, even the law has to be fair, just and reasonable. But still, whether in India we follow substantive due process directly is still a question as per the Puttaswamy judgment, because one judge is saying we have taken substantive due process. Justice D.Y. Chandrachud is saying that no, we have not taken substantive due process. It is merely a substantive challenge to the law and not substantive due process of law. So he is differing there. So interesting read. I think you can carry on your readings from there. If you have any question, you can ask me.
Sir, can you repeat the judgment in which R.F. Nariman was counsel? State of Andhra Pradesh, Swala, sir.
State of Andhra Pradesh versus MC Dolan.
Thank you, sir.
Yeah. 1996 Supreme Court. Full bench decision. Yes, anyone has any question in relation to this? I do not want that you go from here empty-handed. You must know these concepts from
Yes,
here.
excuse me, sir.
Yeah, please.
So the Keshwan and the Bharati case that took place in the year 1973, did it have any impact on the Article 21, 19, or 14 of the Constitution, sir?
Okay, so you raised a very valid question that whether Keshwan and the Bharati had any impact on Article 21 and so on. See, Keshwan and the Bharati was actually basically confining to the part of basic structure of the Constitution of India, though Justice Matthew in Keshwan and the Bharati case gave the detailed opinion on the due process of law. And he says that in A.K. Gopalan case, court rejected the due process clause. Due process clause is actually in relation to the reasonableness of the law. In USA, if you see, due process has to check the reasonableness of the law. So Justice Matthew in Keshwan and the Bharati case said, already the reasonableness you have under Article 19 of the Constitution. Then what was the purpose of rejecting the due process clause, right? When you read the reasonable restriction under Article 19, the word is mentioned reasonable. It means under Article 19 you can check the reasonableness of the law. If any law is depriving you of your liberty, court has to come to the conclusion that whether the law is reasonable or not. So reasonableness is already there. The due process of law is already there. So in Keshwan and the Bharati case, Justice Matthew pointed out this particular point in relation to the due process clause. But otherwise, all the judgments was in relation to the basic structure doctrine.
Sir, I have a doubt. Sir, so keeping in mind the present situation in India, what do you think, like whether India's constitution is favoring the procedure due process or the substantive due process? In clear.
Okay. Now in India, I'll tell you one thing. What is happening is, court do not, when you read the Constitution Assembly and debate, you will find that framers of the Constitution directly, disregarded the due process clause. They even deleted the due process thing. So the judges of the Supreme Court actually do not want to say that they are following the substantive due process, but actually they are following the substantive due process. Look at the judgment which I gave you, Saira Bano of 2017. Very clear word. The Justice Rohingya Nariman has said that you can challenge any law which is unreasonable even under Article 14 also. If it is arbitrary, the law can be struck down. Merely on the basis of unreasonable grounds, the law can be challenged under Article 14. So now court is following the substantive due process of law, but Justice D.Y. Chandrachud in Puttoswamy judgment has taken the precaution, and he says, fine, there can be substantive challenge to the there can be substantive challenge to the law, but we are not going to refer it as a due process, the substantive due process of law. And so he do not want to, the judges do not want directly go against the framers of the Constitution, because it was very clear. And again, they have the ultimate object why due process in that time was deleted was, I told you that many social welfare, 159 social welfare legislation was struck down by the US Supreme Court, okay, in that time. And social welfare legislation was struck down. तो जो fear था Constitution Assembly इनको debaters को, वो ये था कि if they are bringing this due process clause, what will happen? In India also, the court will get more power. And court will start striking down even the social welfare legislation, Minimum Wages Act, Industrial Dispute Act, and all that, Consumer Protection Act. But again, as I told you, there are two era, Lochner era, confining to the individual liberty to enter into the contract. We do not follow. No one follows now that era is gone now. Even in USA, they do not follow that. Very conflicting it was. So in India also, substantive due process is not there with regard to the first era, Lochner era. Okay, in liberty of the person to enter into the contract, that is not there. But the second era which was there in relation to your personal autonomy, liberty, it is still in prevalence in India. So now actually we follow substantive due process. We do not want to say that, but we follow that.
Okay, sir. Thank you.
Any other question?
So we have a question in the chat box from Harshit Raj. He's asking, is the word liberty used to its literal terms?
No, liberty is not. See, the first time when the liberty was given, it was given by the John Stuart Mill. Okay, and he says that you have the liberty and liberty, but he says that you have liberty. And what is liberty? Liberty is a will to do anything what you desires, according to John Stuart Mill. But your liberty is limited to the liberty of the another person. So suppose you are exercising your liberty. Okay, suppose you are playing badminton and you are hitting the shuttle on the face of someone. You are saying it's my liberty. No, your liberty is confining to yourself only. So in India, we have the personal liberty. Personal liberty has a very wide amplitude now. Okay, it is not literal interpretation, but it has gone very big interpretation now. Liberty, as I told you, it is all these are the part of the liberty: right to marry, right not to get vaccinated. Suppose if I give you one example, tomorrow, and I don't think so that there is a delay in this, Parliament may come up with any law making vaccination mandatory for all. Okay. Now suppose if Parliament is making any law which is making mandatory vaccination for COVID-19, because COVID-19 is a transmittable disease. The question is, can you challenge the law? So you will, because it is affecting the liberty. You have right to autonomy. You have the right of self-determination. You will say, I do not want to get vaccinated. This is my right. Who are you to inject me compulsorily? So liberty concept has been extended, but the object of the government is right. Okay, so the law is not unreasonable here. So liberty concept has been extended to many: right to marry, right to procreate. It is wide, it is not a literal interpretation, but purposive construction has to be given. And the law can be made by the Parliament if it is reasonable and it has the nexus. It has the nexus between the object and the law which has been made. But suppose if Parliament tomorrow is coming up with the law, suppose there is a disease which is not transmittable, there is a disease which is not contagious. Okay, it does not spread. And Parliament comes up with the law that mandatory vaccination, and object of it is to maintain the public health. Now court in that time may say that there is no nexus between the object. Why you are depriving people of their liberty not to get vaccinated, because it is not going to affect the liberty of others. It is not going to affect the rights of others. So this is the way the liberty is not confined to literal interpretation. It has very wide meaning. Court in that time also checks all the procedure, as I told you, whether there is a nexus between the object of the statute which the Parliament has brought, and also the law. If there is no nexus, court will strike it down under Article 14. If there is a nexus, court will uphold the law. So in COVID, for example, COVID-19 vaccine, the law can be upheld if it is proper. And liberty has no literal interpretation, as you asked me.
Thank you, sir.
Yes, next.
I hope your query is solved. So next question is from Shubhankar. He's asking, sir, if the executive uses the ordinance route to bring about a law where the necessity for such law through ordinance means is not reasonable, just and fair, can we say it the violation of procedural aspect of due process of law?
Yes, you can. See, it was also a question in A.K. Gopalan case that whether the law made by Parliament, that whether Article 21, the word law, is only confining to the word law made by the Parliament. So court said, in further judgments, court said no, the meaning law has very wide ambit. The law has to be fair, just and reasonable. The word law is not only confined to the law made by the Parliament, but it can go to any point of law which is given under Article 13 Clause 3 of the Constitution of India. When you read the definition of law under Article 13 Clause 3, you will find out law includes the bylaws, the rules, the regulations, and many other things. Okay, ordinance. So even ordinance is taking away your liberty, it can also be challenged under Article 21. And you can strike it down, like the court can strike it down. Okay, so it forms the part of law. But one more thing I would like to give you here, that so law under Article 21 is anything which has any statutory basis. If there is no statutory basis, which has no command of the law, that is not a law. For example, nowadays I am seeing that in Madhya Pradesh and in Uttar Pradesh, the collector is passing the order that whoever is not getting injected for mandatory vaccination and not showing the certificate, their salary will be deprived. There are so many orders which has been passed by, in Ghaziabad, collector has passed. In my hometown itself, the collector has passed in Panna district, MP. In Ujjain also the collector has passed. Their salaries have been withheld. Who are the employees? Their salary have been withheld merely on the ground that they are not vaccinating themselves. So in that time, these order which has been passed by the collector, they are merely in executive instructions. They are not a part of law. So they are anyway invalid. And you can challenge them that they have gone ultra vires. They are performing beyond the law. So law under Article 21 not only includes law made by Parliament, but also the ordinance or any law which has the statutory basis. I hope I have made you clear.
Shubhankar, you can unmute yourself. You have raised your hand.
हिंदी में बोल सकता हूँ सर?
हाँ प्लीज बोलिए.
सर मेरा क्वेश्चन था सर कि अगर ऑर्डिनेंस मीन्स से हम पास कर रहे हैं, लेकिन वो ऑर्डिनेंस मीन्स से पास करने का जरूरत नहीं था उसको, तब मतलब वो पार्लियामेंट्री प्रोसेस से जा सकता था, मतलब लोकसभा राज्यसभा से पास हो सकता था, वैसा कोई नेसेसिटी नहीं था.
हाँ.
तब क्या बोलेंगे कि प्रोसीड्यूरल एस्पेक्ट का
नहीं
वायलेशन?
नहीं 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 नहीं. I'll tell you one thing. शुभांकर, आप कोर्ट जा सकते हैं सुप्रीम कोर्ट जब आपके फंडामेंटल राइट वायलेट होते हैं, ठीक है. सुप्रीम कोर्ट जा सकते हैं. हाई कोर्ट आप जा सकते हैं जब आपके नॉट ओनली द फंडामेंटल राइट बट इवन द स्टैट्यूटरी राइट इज बीइंग वायलेटेड. Court, whenever you go to the court is not concerned with the intention of the government or the motive of the government. Court has no concern with the object and motive of the government, why they are coming with the evidence or ordinance, or why they are coming up with this particular law. Court does not concern about it. Court only sees the repercussion. If that ordinance is violating your rights, court will strike it down. Okay, but there is an exception. There was a judgment, it is called the Ordinance Raj case, DK Wadhwa, okay, where the governor was bringing the ordinance again and again and again and again, and as you pointed out that he did not move anything for the for the legislature. He did not leave anything for the legislature, and every time there was a ordinance again and again and again. And one letter was sent by Mr. Wadhwa, and the Supreme Court took into consideration and entertained that particular question, and court struck down that all the ordinance, and court brought a very great guidelines in relation to the Ordinance Raj, that what should be the ordinance, and on what time it can be, okay, and whether the governor has power to repeat it again and again, so all that. So but generally court has no concern with the intention or motive of the government, but court in that judgment says that it is fraud to the constitution. So you cannot move to the court, but court can entertain the question by itself. You cannot say that it is my right to, suppose if your state they have brought some ordinance, you cannot tell the court, see, it is not violating my right but it is fraud to the constitution. Court has the discretion, court can reject your prayer because court will say that it is not violating your rights, why you are concerning about it. But it is not stopping court to take that into consideration, and court can entertain that particular question and solve it. Both are the two different things. I always tell that you may be the participants of many moot court competition. There is always a question that whether writ petition is maintainable and whether a writ petition can be entertained by the court. There is a difference between the two. Okay, so writ petition is maintainable, is your right, but whether it can be entertained is the discretion of the court. Court, even apart from the fundamental right, can entertain anything under Article 32. But you cannot go as a matter of right to the Supreme Court when it is no violation of fundamental right. So in the similar way, if it is an ordinance, court can take into consideration, but you cannot say that it is my matter of right and my this is their motive and fraud. You cannot go to the court like that. But court can take that into consideration.
Pankaj, hope your doubt is clear. Piyush, you may unmute yourself.
Thank you, sir.
No problem, Shubhankar.
So I have a question. My question is threefold. So the first question, sir, you stated that the Constituent Assembly debates clearly shows that the Constituent Assembly people did not really want the due process of law. So the courts have interpreted cleverly by including by saying that Article 21 must fulfill the requirements of Article 14 and 19. So is that cleverness does really follow the principles of interpretation? This is the first question, sir. Sir, the second question is, why did not the Constituent Assembly wanted the due process of law? And sir, the third question is, sir, we already had...
Can you go one by one? I will forget.
Yes, sir.
I have very bad memory.
Yes.
I'll go one by one. Okay. First question you asked me, see, I forgot. Repeat first question.
Yes, sir.
First question was that whether, okay, I got it. Whether it was the intelligence of the court or cleverness of the court. I do not use the word cleverness of the court. It is an intelligence of the court, and it is the need of the hour. Okay. Because there are so many laws which has been brought by the parliament which are highly unreasonable, which are prima facie arbitrary, and not by the parliament, but it was the earlier laws. For example, the Shariat Act, which was challenged in this judgment of 2017, where the Rowington Harriman said that it is prima facie arbitrary and unreasonable, Shariat Act. And Justice Kurian Joseph agreed with that particular point with Justice Nariman. So it was the need of the hour. It is not the cleverness, it is very much needed in this particular time. Okay, because see, constitution is not something which is very static. If you read the entire Puttaswamy judgment, they have constitution is an organic document. It changes from time to time. Okay, you cannot, there are various interpretations of the law. You cannot just go by the literal interpretation of the constitution. For example, I tell you, Article 124 uses the word consultation with the Chief Justice of India, but Supreme Court has interpreted it concurrence with the Chief Justice of India. Under Article 21, right to life includes right to health, and there are so many rights included. So whenever you interpret the constitution, you have to give the purposive construction to it and not merely the literal interpretation. For what purpose it is there. Second question you asked me, that why Constitution Assembly rejected this due process of law. So the real reason for rejecting is the Constitution Assembly did not differentiate the procedure established by law and the substantive due process of law. They just rejected simply. And what happened, I told you, this constitutional expert, Mr. B.N. Rao, he went to USA and he had discussion with Justice Frankfurter, who was the US Supreme Court judge in that time. And in that time in USA, they even used it to invalidate the social welfare legislation also. So everyone in the Constitution Assembly that time, they were afraid that if we get this due process clause, the judiciary, like the USA, they will get so much of power that they will not consider parliament anything. Parliament is coming up with the law. And 5 gentlemen in the Supreme Court sitting, they will say that, okay, no, it is unreasonable. And the law is struck down. So this was the fear which they had. So they did not go to interpret the procedural due process, substantive due process, and it was first time done by Justice Fazal Ali in A.K. Gopalan case. And from there, it has taken a different shape. Even Justice Nariman has very clearly mentioned this, that what was the intention of the framers was to restrain themselves giving the substantive due process of law, not the procedural due process of law. But now the time has changed. After 70 years, you cannot just go by the wordings of the framers of the Constitution Assembly. And there are so many times when the Supreme Court has gone against the intention of the framers of the Constitution. One of the cases, Supreme Court Advocate on Record Association versus Union of India, 1993, first judge case. Then again in 1999, second judge case. Then in third judge case. First case was SP Gupta. Second case was Supreme Court on Record Association, 1993. 1999 third judge's case, in presidential reference, in all the 3 judgments, and even in NJC judgment, court did not take into consideration the framers of the Constitution, and court said that the time has changed. So sometime court go by the framers of the Constitution in the time of need, and sometimes they do not go by the framers of the Constitution. So in even second judge case in 1993, Supreme Court said that framers of the Constitution did not visualize that what will happen after 40 to 50 years. Like the framers of the Constitution never thought that there will be emergency in 1976 by Indira Gandhi. They never thought it. So they did not provide any provision like that. In the similar way, framers of the Constitution did not provide any provision for governing the political party or the coalition of government. But now see how you are facing the difficulty. The MLAs sitting in the bus are running here and there. So now it is the time for the judiciary to come up with the law if parliament is not coming up with the law. Okay, so framers of the Constitution has said something else, or if they had not said something else, sometime court take that into consideration. It is the discretion of the court, and sometime court does not take that into consideration. Discretion of the court. I hope I have made myself clear to you. Third, what was your third question?
So my third question was that we like the Menka Gandhi thing was in 1978, and before that there was a judgment of Raj Narayan versus Indira Gandhi. I'm not remembering the case. So sir, we already had the judicial review thing. So forgive me if I'm wrong, but can we say that the procedure established by law plus the judicial review is equals to the due process of law?
Yes, absolutely. So I'll tell you one thing. When you read this Puttaswamy judgment, consisting of 689 pages, specifically the Justice D.Y. Chandrachud judgment, he has given these 3 principles here. And he said that why now substantive challenge to the law is allowed. during the time of Constitutional Assembly, they did not allow any substantive challenge to the law. But now substantive challenge to the law is allowed, because he said there are many precautions which we take that into consideration. First is, there is a presumption of constitutionality. Okay, so we are not like USA, that if something is against liberty, we just invalidate the law. So Justice D.Y. Chandrachud said, no, it is not like that. There is a presumption of constitutionality. Every law which has been made by the parliament will be presumed to be constitutional, and it is on the petitioner to prove that how it is violating the fundamental rights or something like that. Second is judicial review, that court has the power of judicial review. And third is the separation of power. And from separation of power only the judicial review has come into existence. Okay. And as you said, that it is the power of judicial review only which has taken all this procedure established by law to the due process of law and substantive due process of law. And here I would like to tell you one thing. There is a judicial review, there is a two model of judicial review actually. One is called the technocratic model. Okay, when you read the administrative law books, you will find out that in judicial review there is one model called the technocratic model. In technocratic model, what is the purpose of the court? Court sees that no one is crossing the Lakshman Rekha. Executive is not crossing the Lakshman Rekha. Legislature is not crossing the Lakshman Rekha, and even the judiciary is not crossing the Lakshman Rekha. If anyone is crossing that Lakshman Rekha, that particular boundary of the separation of power, the judiciary will strike it down, the law. And the second purpose of the judicial review is to interpret the constitution in organic way, okay, according to the changing needs of the society. So it is the second limb of the judicial review, on the basis of which the court has interpreted the whole procedure established by law to the point of substantive due process of law. Okay, so due process of law is a part of, obviously is a part of judicial review. Understood? Do you have any doubt?
Yes, sir. Thank you. Yes, sir.
Thank you, Piyush.
So the next question is from Ashwarya. She's asking, recently the UP government passed a law on limiting the number of children to 2. Can it be challenged under infringement of personal liberty?
Yes, it can be challenged. It can very well be challenged, and there are many grounds actually on the basis of which you can challenge. First is, according to me, if you take my view, the law is divided in two parts. I have not seen the law in detail, the bill, but how much I have read, I have seen the bill is divided in two parts. First, for the people who are businessmen, and second are the people who wants to apply for some government job. Okay, so the law is only confining to the people who want to apply for the government job. So suppose, what is law saying? Law is saying that if anyone who wants to apply for the government job, or if anyone who wants any benefit in the scheme which has been brought by the government, is having children more than 2, they will not be given the benefit of these particular schemes, government scheme, and they will also have the problem in getting the job. This is the law. But now there are other categories of people in India. There is a great ratio of the people who are doing business, who are running the grocery shop, who do not care about, or who have the very good business. They do not care about the government scheme. They do not care about the getting job in the government. Okay. So the law actually is exempting them. If you say this, law is saying that you can have more than 2 children because you are not going to apply for the government job. So anyone who does not want to, or who is not required to apply for the government job, or any person who does not want to apply for this beneficial scheme of the government, they are exempted from the law. So directly there is no nexus. If you look at this Article 14, if you read the principle of reasonable classification, it says the classification must be based on intelligible differentia, and then there must be nexus between the intelligible differentia and object to be sought by the statute in question. So what is the intelligible differentia? You have created the 2 classification of people: the people who do not want the benefits these schemes, and the people who are who wants this government job, the poor people. Okay. What is the object of the law? The object of the law is to stop the population, or to have the control over the population. But you are stopping only one category. You are not stopping the another businessman category. Okay, because there is no penalty, there is no punishment for that. So the question is whether it is not violating Article 14 of the Constitution of India. First thing. If it is violating Article 14 in any way, it is violating Article 21, because as per Menka Gandhi judgment, you can interlink the article. So here it is seizing the liberty of the person. Already, if you look at this, already we have in India very limited liberty. Okay, we do not have the liberty like USA. The Constitution Assembly has made it the personal liberty. Personal liberty, we have the right of self-determination, how many child I want to, which is my personal body. I want to have 10 children. Who can stop me? I will feed it. I'm not asking the government to feed them. Okay. So now this liberty, if I am able to prove that this is unreasonable, arbitrary, not based on intelligible differentia, it can be challenged not only under Article 21 but under Article 14 of the Constitution of India, while saying that this is an unreasonable classification. And in order to have the better understanding of this particular law which has been passed by UP, I have to go through that particular bill. I have not gone through it. So I think for now it's fine.
Yes, sir. Thank you, sir. Participants, do you have any further questions?
I just want Ridhi, everyone that you should not go empty-handed from here. You must know these basic concepts from here. So if tomorrow anyone is asking, you should be in a position to answer them properly. Okay?
Yes, sir.
Okay, Ridhi.
Okay, so then I shall proceed with the vote of thanks. On behalf of Team Law Internships, I would like to extend my heartfelt gratitude to Advocate Pawan Reley, sir, for taking out time from his busy schedule and interacting with the young minds today. So it was a truly enriching session, sir. Thank you again for sharing such wonderful knowledge and experience with us. Thank you so much, sir, for coming here.
Thank you, Ridhi. Thank you, everyone.
Thank you, dear participants, for joining and being a wonderful audience. Thank you so much.